Hi, I'm Diana Corrigan with the Bloomington Area Arts Council. I'm the Development Director. Tonight we're very excited because we've gotten cats over here to tape us, and we're going to try to continue doing that so you guys, if you miss one, you can see it on cat. So we're really excited about that. The difference that's going to happen is that when you guys start to ask questions, you'll actually have to just go up to the microphone there. So that's just the difference in how we've normally done it in the past. Just a couple of announcements before we introduce our speaker for tonight. Our next session is October 25th, and it's Art and the IRS. And we also need topics. We do have some topics from some of your last surveys, but I encourage you to fill out a survey at the end of the night tonight. Give us feedback and also give us some information on some new topics that you would like for next year. And we haven't even scheduled our November topic yet. So let us know what you want for Artists After Hours. October 7th is our gallery walk, our next gallery walk. I also would encourage you, we have our third annual Arts Leadership Awards. The luncheon is going to be in February, but right now we have the call for nominations. This is, you can nominate any artist or arts organization in our 5-county area. So if you're interested in nominating someone, and it's anyone who has basically directly influenced and contributed to the enrichment of life in our community through the arts. So it's an artist or an arts organization or even an individual who gives financial support or volunteer support, what have you. So pick up one of these, and nominations are due by November 4th. Also, we always like to put out a call for instructors for our arts education classes, whether it's belly dancing, which is very popular right now. If you have something unique and interesting, ceramics, painting, whatever it is, something unique and interesting that you would like to teach in the winter or the spring or the summer, we'd like to hear from you. Contact Roger Meredith, our education director, and he will talk to you about how to sign up to teach a class. His business card is right over here. You can pick that up at the end. Every Monday, there is now an open painting studio in our large classroom from 12 to 3:30, is that right? 12:30 to 3:30, and they're just asking for $5 contributions. So if you are a painter and you want to come to the open studio, feel free. Is there anything else about that? Okay.
Don't need to sign up, just show up.
Yeah, you just show up. So no RSVP necessary, just show up. Yep. It is every Monday from 12:30 to 3:30 in the large classroom. And Mary Elbert from the gallery, or our gallery committee, is organizing that.
I'll just add,
Yep.
it's in all media. I mean, we have people bringing a variety of media to work in. Some people have, I sound worse than I think. Some people set up still lifes. Occasionally, we will have instructors there to teach various techniques. Sometimes, but it's primarily instruction.
Okay. And as always, I encourage you to become a member of the Arts Council because your membership contributions help us to put on programs like this, which are free, and we like to give them for free. So give a donation to the Arts Council. And Nancy is going to pass out membership cards, and she is also going to introduce our speaker. Actually, I'll pass out the membership cards, and you can introduce.
If you've been coming to these since we started offering them about January or February, we've had about 8 of these. If you figure that's a $5 donation per month, that would add up to your $40 artist membership, and we would like to encourage you to become a member of the Arts Council. Here's some more evaluation forms. Just going to pass those down. Okay, I'm going to introduce our speaker tonight. Jeff Ankrum is a newly appointed board member of the Bloomington Area Arts Council. Jeff had a variety of advanced degrees in French, and then I heard him admit that he had a midlife crisis and decided to go to law school. So he did that. He graduated in 2004. Is that correct then? He'd also spent some time in the Peace Corps in Morocco, but Jeff's specialty is copyright law. So I'm going to turn this over to Jeff right now. And Jeff, I think we'll encourage questions more towards the end, unless they're very brief for clarification. Jeff has a lot of material he wants to deliver to you tonight. and we'll try to save the longer, more complex questions for the end, all right? Thank you. Please join me in welcoming Jeff Ankrum.
Thank you. And it's true, we've got a tremendous amount of material. My mission this evening is consciousness raising, so that when an issue comes up, something in the back of your mind will spark and say, I know there's something legal dealing with this. I can pull out that handout and get some lead on where to get information about it. So forgive the speed with which we will fly through things. At the end, I'll be glad to entertain questions, and I guess during the munch and mingle session that follows, I'll be glad to talk with any of you also. So first of all, thank you all for coming. Would like to say a word of thanks to PC Max, who gave me a break on running the projector, and thanks to the Waldron staff, the BAC, who helped arrange this. So art law touches on a great number of areas of law. There's more to it than just copyright. And this evening we'll touch on a few areas attached to copyright, but our real focus will be copyright. People dealing with arts and publication end up dealing with issues in these various domains. I think one of the main concerns that may come to mind outside copyright will be things like contracts and First Amendment issues. So I won't address those very closely, but if you have questions, you'll see if I know anything about them. I think it's important to talk just briefly about the sources of copyright law. You can go online, pull up the copyright code and Title 17 of the US Code, and get a false sense of security that you're seeing the copyright law right there. Actually, copyright law starts with a section in the US Constitution that authorizes Congress to regulate matters of copyright and patent. Congress followed through, has passed a great number of laws, largely in the Copyright Act, but also scattered around in other areas. That law is influenced by treaties. It's influenced by lobbying, especially from entertainment firms, software companies, the film industry, the music industry. When something goes to court, things that can be considered include the legislative history, the documents that the Senate or the House of Representatives prepared when they were debating or when committees were reporting on the law. On top of that, you have the federal court decisions, and in some areas like the rights of publicity, the rights of celebrities to the use of their image, state law kicks in. So one of the things that makes me most nervous when I'm looking online and seeing people's copyright statements is that they will quote directly from the fair use statutes saying, I'm putting this person's whole article on the internet because it's for educational purposes and I want to educate the world about this. If you went to court, the court would not just look at the plain language, they would look at previous court decisions, legislative history. So don't be too literal in looking at the language of the law. The constitutional purpose for copyright in the US is rather different from the purpose recognized in actually most other countries. The Constitution says that Congress is authorized to pass laws for copyright and patent to promote the progress of science and useful arts. And here I believe science refers to knowledge, and useful arts more to things covered by patent. The emphasis on promoting the progress of science and useful arts, the emphasis is not on rewarding hard work. It's not on giving people access to information. It's on giving an incentive to create. And this may be a late 18th century notion of what incentives are. There's a tremendous amount of debate about it. But when it comes down to how a court is likely to decide something, the philosophy of copyright that's going to be in play is This law is here to encourage production. It is not there to reward hard work. So we'll see some things where people put in tremendous amount of hard work and they can end up in a tremendous amount of trouble. By the same right, you can spend an awful lot of time pulling together resources or something, and that may not be covered by copyright, even though you put in a tremendous amount of work. The most famous example with that involved a phone book where the plaintiff said, we spent all this time, we spent a fortune assembling all of this material. And the court said, that's too bad. There's no creativity involved. And our law rewards creativity. It doesn't reward sweat of the brow. So what is copyright? Literally, it is the right to copy. It is a limited monopoly, starting out by the artist, to copy, to distribute, to make other uses of the work. So when people are talking about copyright, often they'll ask, who holds the copyright to this? And that made a little more sense before the copyright reform that became effective in 1978. Today, copyright is a bundle of rights. It's an infinitely divisible bundle of rights. So you create something, and say you create a sculpture. By contract, you give one company or one person the right to make castings and reproductions of the sculpture. You give someone else the right to sell and distribute those copies. You give someone else the right to reproduce that on greeting cards. Someone else, you give the rights to put on Christmas cards. It's infinitely divisible. So when you're thinking about who has the rights for something you want to use, perhaps, if you want to do a drawing of a sculpture and then put it on greeting cards, you need to find out not who has the rights to the work, but who has those particular rights. And when you're trying to track down rights, it can be tremendously difficult. If the work has been published at all, if you go to the publisher, they're more likely to have some record of who has legal control of the thing if you can't find the artist. And sometimes the artists don't understand who has rights. So if you start with the publisher, that should at least give you some help. So next question, what can be protected by copyright? Copyright protection can go only to things that are original works of authorship and that are fixed in a tangible medium of expression. So the original works of authorship, there has to be some level of creativity. So if you take yesterday's newspaper, you copy it by hand so it is absolutely identical, you've done a lot of work and you can't copyright your work because there's no creativity. If you do a bad job of it, or if you're sloppy, or sloppiness, no, but if you get a little imaginative and you start tweaking some things in there, then there's creativity, and those tweaks can be protected. But literal copying is not copyrightable. The second requirement, that things be fixed in a tangible medium of expression, the fixation requirement. If you have a wonderful idea for a painting, you describe it to people, and then somebody goes out and creates a work based on your idea. In most states, you are sunk. Under federal law, you are sunk because you've merely told someone your idea. You haven't put it in a fixed medium of expression. If you went ahead and drew the picture and someone else copied it, then you'd have a claim. I would argue that even if you tape recorded yourself describing in detail, and in adequate detail, so that someone looking at the painting would say, all of these features are here. The person who made this infringing work knew about this. Then you'd have a colorable argument of infringement because you had fixation. You'd recorded you had recorded a description of the work which someone made a visual copy of. But if you're simply sitting there speaking out ideas, that is not protected, at least not in Indiana. There are some states that have laws protecting unpublished works. I need to back up. That are protecting unfixated works, works that haven't been written down yet. But for federal protection, you have to have some tangible record of it, even if it's on a computer disk, just on your hard drive, in an email note to someone. All of those fulfill the fixation requirement. If it's just an idea that you've told someone about, it's not protected. So what rights are included in the visual arts? What rights are protected? What rights are covered under copyright? The first is the right to copy, the reproduction right. The second is the distribution right, the right to sell or pass out copies of things. The next is the public display right. So you create a work, maybe you have it in your studio, and then someone decides when you're out to put it in the window of your studio so the world can see it. That's a violation of your copyright. That's a public display without your permission. There's a public performance right that doesn't come up with physical works of art, but with performance art or film. You also have protection there. Performance art is another area where maybe you've done the performance 10, 20 times in public, but you've never written down a description of it, you've never videotaped it. If someone else goes out and copies it, you may not have copyright protection. So before you're performing things in public, you might want to jot them down or just tape them. And a final right, one that people get into a lot of trouble with, is the right to make derivative works. So if you hold the rights to a work, you have the right to decide whether to authorize someone to make a photograph of that work. If you have a sculpture, someone wants to make a drawing of it, you have the right to say yes or no. These are tricky things, even if you have produced a sculpture that's standing in a public place, under privacy laws, yes, people can take a picture of things that are in public places. That doesn't mean that they can take a photograph and put it on a greeting card or a note card, or draw a picture of the sculpture and sell it. If the sculpture is still under copyright, it doesn't matter that it's standing out in public. Copyright still applies. And then another little area of copyright that we'll be talking about in a few moments will be moral rights, which are sort of recent importations. So I'll just mention them right now and we'll come back to them in more detail. So let's look at a few case studies here. Just this. So you might not notice it first. This is the back of a grave marker. An Indiana artist did a pencil drawing of this very nice, in this context, certainly a very comforting scene, a wooden bridge crossing over to the other side of the water. Lovely piece of work. The author did not authorize the copying of this drawing onto the back of the tombstone. In fact, the author was very upset to find out that it had been copied, that there was a derivative work. She created the work. She had the copyright for it. It was copied onto the back of the stone without authorization, and one thing that made things worse and legally more complicated is that her signature was removed and the signature of an employee from the monument company appeared in its place. So this got legally complicated. So what's at issue here? First, there's the reproduction right, the right to copy it. So that happened while, even if someone at the Monument Company just made a photocopy preparing, strictly speaking, that first copy was a violation. The second was making this derivative work, another work using the first one, and then public display. I've discussed this work with one person. My understanding is this side was facing a thoroughfare, was facing a street, so people driving by could see a really lovely scene. And I want to emphasize, I can understand why the family member thought it was a lovely thing to have there. It's a lovely drawing. The problem is permission was necessary, and the people who needed to ask permission didn't ask. A second case showing something that's not a derivative work. This is, it's actually, given the distance, it may be easier to see here. This is a greeting card showing a painting by Annie Lee, wonderful artist. It's called Blue Monday, and I think we've all felt like this on Mondays. So she created a painting. She authorized the production of the greeting card, and then a company called ART bought a stack of the cards, sort of very neatly cut them, mounted them on a tile, on tiles, and put an epoxy cover on them. The court found that this was not a violation of copyright. For every tile they produced, they paid money for the card. They hadn't altered the work. Yes, they were charging some markup on it, but this goes into the first sale doctrine. Once you buy something, especially with books, if you buy a book and you want to resell it, contracts may be shifting here, but for today, when you buy a book, you can take it to a used bookstore and sell it. The same principle kicks in with this card. Once you buy it, you can frame it, you can give it away, you can send it to another country, you can mount it on a board. The author, the artist has already received what she was asking for. She's already received the sale price. So this is not a derivative work when it's mounted on a tile. Thank you. So Robert Rauschenberg, early in his career, started doing combines, these paintings involving collage, pieces of newspaper and all of that. Then before long, he started doing silk screens and prints of his collages. And then the lawsuits started. He used an image of a diver from an ad, and the photographer who created that image said, this man is reproducing the work in each copy of the print without authorization. He's recontextualizing it, he's putting washes of color over things. This is a violation of copyright. And what Rauschenberg finally did was simply to start taking all of his own photographs for collage. The law of copyright and collage is really pretty messy. I'd say you're much safer when you're doing the original work. If you're reproducing that work that has other people's images in it, it's getting a lot riskier. One thing you'll find in copyright law is there's not a lot of yes and no. There's a lot of, well, this is riskier, this is less risky, and a lot of, I don't know, the courts haven't ruled on that yet.
But the original was not about violation?
I don't want to say that. Partly because, recontextualizing things may create a derivative work. So it's something you might want to get somebody to do some research on. And later on, I'll bring up some sources for help. But yes, it's a question I've seen contradictory answers on and that I'm a little concerned about.
So if he bought the original pieces, did not alter them, glued it to the canvas, took a picture of it,
then it's risky because then he glues it to the canvas and then takes a picture of it. He's reproducing their images.
supposedly the person that bought it put it on a coffee table and then sold it.
You know, if it's simply glued on there, the court in the Annie Lee versus ART case didn't really address that squarely. So I don't know if we know. The more neutral the coffee table, the safer that use would be. If it's a coffee table with dragons and it creates a context that the artist feels might damage his or her reputation, and say you're more likely to get sued. I don't know whether, it's not clear what the likelihood of winning is, but I'd want to do more research before I went any farther on the gangplank. I may have already fallen off. Actually, it's not a gangplank, but you know, that plank that people go over. So next question, how do I get copyright protection for my work? Before January 1st, 1978, it was a little more complicated. Today, nice, clean, clear. When you create the work, when it is fixed in a tangible medium of expression, when you start making the pencil marks on the paper, when you click the shutter on your digital camera, it's fixated and it is protected by copyright. So getting copyright protection isn't the hard part. Sort of getting other people to respect it may be a little more difficult. One thing you can do, if you're putting a copy out there, is put on the copyright symbol and a copyright statement. It doesn't make the difference between having copyright and not having copyright. It does remind people that someone out there is interested in the rights to this. It reminds people that copyright is out there. Copywriting something is a simple proposition. If you've got a whole portfolio of materials, you can register a whole collection of materials at the same, unpublished materials at the same time by submitting photos or photocopies or slides to the Library of Congress. Registration fee is $30. So it's not that burdensome. If you go to the website of the Library of Congress at the Copyright Office, which is on the last page of your handout, it's got all the instructions, the forms. It's really pretty simple. You don't need an attorney, though. There are attorneys out there who charge big money for this. There's sort of the folklore of the poor man's copyright, and I thought of using more gender-neutral language, but the technical term out there is poor man's copyright, where you put things in an envelope, seal it up, and mail it to yourself. It doesn't do you much good. If it helps you sleep better at night, do it. You know, sleep for the price of a stamp is a great deal. That way, you have proof that your image existed on this date. So if somebody else brings out a card with your image on it, your drawing, the photograph you took, you can prove that you had it first. So songwriters do this. Apparently, I understand that songwriters in prison do this routinely. Not that I have that from secondhand knowledge. If you're still sort of attached to this notion that I don't want to go through registering with copyright. I'm just going to throw it in the envelope and mail it to myself. One thing that's in the middle ground, it doesn't have as many advantages as copyright registration. It's just get a photocopy and get it notarized. By law, a notary public in Indiana can't charge more than $2 to notarize something. It costs more than the stamp, but you can open the envelope and still have proof of the date on it. So what advantages are there then to registering for copyright? If you register before infringement, or if the work is being published within 90 days of publication, you have certain rights if a problem comes up. If there's a lawsuit and you've registered in a timely manner, the other side, if you prevail, has to pay your attorney's fees. Other thing is, instead of you're having to prove how much money you lost, how much money they gained, the law can kick in and specify a range of damages. So if you've registered, they're likely to have to pay more, and you don't have to do as much work to prove how much was gained or lost. So the question, do artists have rights other than under copyright? Other than, obviously the First Amendment rights, which aren't really our focus right now. There are some moral rights. The moral rights are a legal regime more common in Europe. Sort of, France is sort of the capital of moral rights. These include a right of attribution, the right to have your name attached to your work, and to make sure that your name is not attached to something that's not your work. And to make sure that if someone has, let's say you've done a nice sculpture and someone has mutilated the sculpture, has altered it in some way that you think would really damage your reputation as an artist, you can make sure that your name is separated from it even though you're the author of the original work. A second moral right, and some of these are coming into US law, is a right to the integrity of the work. This is a right to prevent mutilation of the sculpture. And again, especially where the reputation of the artist it could be harmed. A third moral right involves resale royalties. And some states in the US are starting to pass laws saying, if you've sold a painting to someone, and then 10 years later, they sell it for 20 times the price, under that state's laws, you get a percentage of that new sale. So it's a nice little perk for the struggling artists in the golden years. But you gotta struggle first. And then finally, in some regimes, there is a right of withdrawal. Let's say you are wild in your youth, you do scurrilous, scandalous paintings, and then you become wiser and more cautious in your life, and you have grandchildren and you don't want them to see that painting. It can cost you a fortune. Under French law, if you want to withdraw the work and it's in a gallery, you have to pay what the painting costs. But if it's important to you, the owner does not have the right to refuse to sell it back to you. So a place where moral rights for visual arts have come into US law is in the Visual Artists' Rights Act, which is now part of the Copyright Act. It applies only to certain works, only to visual works. For prints and sculptures, it does not apply if there are more than 200 copies. So if it's a series of prints, you've got certain moral rights as long as you personally signed and numbered each print. If somebody else did it, or if it's a larger run, the moral rights don't apply. These rights include the right to claim authorship. So if you produce a statue, it's put in public, you have the legal right to insist that your name is put there identifying you as the author. You also have the right not to have your name associated with works that you did not create. One area of the law that I'm curious about there is, what if your name is put onto something of which there are 5,000 copies instead of 200 or fewer? We hope common sense manages, but I don't know that the courts have ruled on it. Maybe in the legislative history. You also have a right to keep your name off a mutilated version of your own work. I don't have a picture of it, but famous case, New York lobby of a large building, there was a statue. People decided the statue was in the way, so they get a great big bandsaw, slice it in half, and put the two halves against the walls. That is considered a mutilation. So you would have a legal right to get a court injunction saying, they have evil plans for my sculpture, please judge, stop them. Or you could sue for the mutilation of the work. And you have a limited right to prevent the destruction of a work. So if you've got a large sculpture that's out in public and it's made out of concrete and they've sold the land and they want to just bulldoze it, you've got some rights, you can get some time to try to remove it. But these are the beginnings of moral rights for artists in the US. Just a quick word on jurisdictional questions. If your art is being shown in France, French law applies. If there's, if someone has bought one of your works in the US and they've altered the work and they're displaying it in France, I believe Germany does the same thing, but with France I'm certain, you have the rights under French law to get that off-public display, to get your name off it, to sue in a French court for the mutilation of the artwork, even if the mutilation was done in the US. So for those of you who display in France, well done. This next matter is especially for people who do crafts. It's a question of design patent, and here I'm spilling over a little bit outside of copyright. If you've produced, let's say, a cable knit purse, for those of you who read the New York Times, a cable knit purse with a red bow on it. There's no part of that you can detach and say, here's the ornamental item, here's the hood ornament from the car. If there's some detachable part of it that's the ornament, you can copyright that separate element. If, however, you've got a useful utilitarian object, such as a purse, copyright isn't available. Copyright applies to creative works, expressive works. And for better or worse, the courts, the law, the Constitution say your cable knit purse is not an expression of how they could say that, I don't know, but they're just like that. So an alternative is to get a design patent. And that's a whole different batch of law out there. I just want to draw your attention to it. One thing to bear in mind with patent issues. With copyright, you've got protection from the moment of creation. With patent, you have protection from the time of application to the patent office. So if you've got a great new design for some utilitarian object and you want to protect it, the short term, you may say this purse is a sculpture and I am copyrighting my purse sculpture. But if you're going to want a design patent, apply for that before you start approaching merchandisers, because this is an area where craftspeople can get ripped off by mega stores.
If the item is produced while in school and then the work is placed on the school's website, what rights then does the artist have as far as being protected if someone else sees the artwork or sees the object created on the website and then begins to reproduce it?
And I'll summarize the question so it's on the mic. The question was, what if a student produces an artwork, it goes onto the school's website, someone sees it there and starts reproducing it? And in this scenario, the fact that it's on the website really doesn't make any difference other than it just makes it easier. It doesn't make a legal difference. But if someone is copying your work without permission, without authorization, it's infringement. And so the options involve approaching and talking to the person, sending a cease and desist order, getting an injunction. A lot of legal action involving copyright can't be started unless the work is registered. So you can register it even though infringement has already taken place. That can take a while, and if you're in a hurry, sort of the accelerated registration is, it's $200 some or $300 some. It's steep. And we'll get to internet issues again in a moment. So the public domain. The public domain is something we've all heard of. When something falls into the public domain is horrendously complex. You know, we've all heard sort of the simple answers. Anything published before 1923 is in the public domain. True. What about things that were produced before 1923 and published only later? There are things under copyright now that are more than 120 years old. There were provisions in the Copyright Revision Act saying if you've got something that was produced before 78, but you publish it before December 31st of 2002, you get copyright protection through December 31st, 2047. And it doesn't matter whether that unpublished material that you're publishing now, you know, it could be a letter from 1800. So the date when something is produced doesn't tell you whether it is under copyright or not. The date of publication comes closer. It's a horrendously complex matter. In the resources section at the end, I refer you to a 4-page chart by Peter Hurdle. Print it out, copy it. He says right on there, feel free, reproduce this puppy. It's a wonderful chart. It will take you a while to sort through things and figure things out. But it is, to date, the best resource on figuring out whether something is really in the public domain yet or not. So the question, I see this image all over the internet, does that mean I can use it? Well, a student artist might object. The student artist might sue. So the fact that you see an image all over the internet doesn't mean it's okay to use it. There's a lot of infringement out there. Next question, what if I go on the internet and there's my picture? And maybe my school put it on the website, but now it's on somebody else's website, and I don't like it. The procedure, you can get your computer friends to help you. You find the internet service provider for that website, and they will have a notice and takedown policy. This is mentioned on your handout. It will tell you the procedure for informing them that there's an infringing work on the website, and the procedure for you to get it removed. And it may involve some legal help. It will probably involve getting copyright registration, but it'll be spelled out there. You look for the notice and takedown policy. So when you're looking at public domain materials, there's still some danger zones. Dover clip art books, fabulous, fun things. There are other people out there producing them. This is not the one I thought it was. Thing to be careful of, even if the individual clips are in the public domain, there is copyright protection for the selection in that album, so that if you were to reproduce the whole album, you're infringing on Dover's copyright. Dover has a policy. I understand that it's a maximum of 10 clips in a given work, over that, they would like some royalty or a permissions fee. So if you're doing a collage and you're using a lot of clip art, mix up the sources.
The front page or the copyright page, it usually tells you 6 and I'm doing research
Go ahead. Thank you. So other things where you're looking at something, you're saying public domain, where you want to stop and think for a moment. If you're looking at a photograph, you want to use a photograph of a 500-year-old sculpture. You know it's in the public, that the sculpture is in the public domain. In the US, the photograph, maybe 10 years old, 20 years old, the photograph can be protected by copyright. It's considered a thin copyright, but you may need authorization to use that image. Also, if you're getting images from an archive or a museum, there may be something in the written agreement, a contractual obligation with the archive, the museum, the library, saying you are not authorized to use this image for publication without seeking permission first or paying a fee. Just a reminder on something we brought back earlier, the fact that something is in public doesn't mean that it's in the public domain.
Is it true that some works that were public domain have been copyrighted again?
There are some works, when the US joined the Berne Convention, it brought rights from the Berne Convention into US copyright law. The biggest alteration there, well, one of the alterations was that foreign publishers, foreign authors and artists who had lost copyright because they failed to renew the copyright in the US had those copyrights restored. And there's a process by which they should notify people that they're reclaiming the rights. There are no Americans whose lapsed copyrights come back under. It's only with foreign authors, I think largely with the notion that they had less opportunity. It was more difficult for them to follow what the US laws were. A couple comments here. This is a story quilt by Faith Ringgold of a Sunday school picnic. This is an illustration of why with something other than sort of small commercial projects, you might want to hang on to many of the rights. She sold this quilt to a museum in Atlanta. She kept the rights. The museum wanted to produce a poster. The museum asked permission. They struck a bargain, produced a poster, very nice poster, which I have in my office. Then a television program had a scene set in a church basement. And to help set the mood for respect, tradition, and all of this, in the background, they had this poster in focus, scene after scene after scene. Faith Ringgold, who had kept the rights to her artwork, sued. Yes, it was an image of the poster of her quilt, but in there it was the image of her quilt. She won. The television station's argument was, this is minimal copy, this is de minimis. And the court said it was in focus, it was repeatedly in the scene, you could see a great deal of it. This was not such a little picky use of it that it should escape our notice. Sort of the other side of that principle in the movie Seven, which is one of the goriest movies, if you haven't seen it, well, you're grown-ups. There's a darkroom scene with black and white photos hanging up. Some of those were copyrighted photos by an artist who had not given permission for their use in that film. The court said, this is a minimal use. You can squint and stare at the screen, and unless you know these images, you would never recognize them. So it's a mushy standard of when something is too much or not enough in a film. One of the most egregious cases was in the film 12 Monkeys, where architect Lebbeus Wood's entire fictional room was taken for a scene design, and they just built a fictional room. Mr. Woods went to the movies and saw his imaginary room in front of him with people moving around in it. That case has sort of entered the folklore as, well, somebody went to a movie and thought he saw a chair that he designed. Well, the chair was unusual, but it was the whole space-age sci-fi room. So that one was over the top. So I'll just dashing through here, an interesting case of what happened under the old copyright law. Before 78, copyright protection was not automatic. The Chicago Picasso on Daley Plaza was a big deal. A model of the sculpture, before the full thing was built, the model was displayed at the Chicago Art Institute. There were receptions, they were passing out little models of it, photographers were invited in to take images of it, and there wasn't any copyright statement for the model. They come along, they build the full-size one, then somebody wants, letter edged in black press, wants to start distributing models of it, or little short souvenir size. Chicago sues, and the court says, you know, you displayed the model without the copyright statement. The model went into the public domain. This big thing out there is a copy of the model. This big thing doesn't show imagination or anything. It is a careful, literal copy of something in the public domain, which is why you can get really cheesy copies on eBay for not much. I won't tell you how much I paid, but you can get really cheesy things cheap because there are no royalties.
So that's just because they didn't have the copyright mark on the models that were distributed?
It was the wooden maquette of the sculpture that was on display. That was the one that was lacking the copyright symbol.
So size doesn't play an importance. If someone takes something you make and makes it 10 times bigger.
Right.
Okay.
Yeah, so if you do a little sculpture like that and somebody builds a huge one with great sweat of the brow, well, they've sweat a lot, and then they'll probably sweat more when they hear from your attorney, because something bad.
So would that copyright be used differently today? You said back then before 78, today, how courts view copyright, it would be viewed differently.
Yeah, and the change really hasn't been in the courts. The change was Congress saying, you know, copyright affixes from the moment something goes into a tangible medium of expression. So those were the dangers of the old days. Just an example of the precautions that are being taken today. Midnight in the Garden of Good and Evil, the book came out, it had a sculpture of the Bird Girl statue in Savannah on it. The artist was still living. They got permission to use the statue. After the film came out, the family moved the sculpture. When they were preparing for the film, they sought permission to have a copy of the statue made, got permission to include it in the film, and they cleared all of those permissions to make sure that everything was okay. They did get sued by the artist who did the jacket photo for the book, but the court said, you know, this is really a different image. There's enough difference in the composition that no dice. I will try to fire through this very quickly. because this is a vast area. But fair use. It is a big, messy area. This is probably the area of copyright that's gone to the Supreme Court the most, certainly for visual art. And this is an area where you really need to look at the explanations, the court decisions, and not just the plain language. And I'll just go through this fairly quickly. There's some excellent resources on the internet that I've mentioned on the handout. So go to Stanford's Fair Use site. It will give you more than I could give you in a few moments. Here, just as an example, there's a fuzzy picture on the left, so I didn't have a better image, of two people with a string of puppies. These are puppy breeders. They hired a photographer who did a long shoot, finally got an image he really liked, put it on a note card, no problem. Artist Jeff Koons gets a copy of, sees the note card, thinks it's cute, and produces a sculpture, making people look a little goofy, adding sort of goofy colors, and he gets sued, saying, "You have made a derivative work of my photograph." Koons says, "No, this is parody. If we're making fun of something, it's fair use." Well, the principle is right. However, with parody, you have to be making fun of the thing you're copying. When asked what he was making fun of, he said, "Oh, I'm not making fun of the picture. I'm making fun of society." Wrong answer. He lost. So the correct answer would have been, "I think this photo is just too corny, and I wanted the world to see how corny I thought it was." That argument would have stood a very good chance of winning, I think. There's some issues of parody, also trademark issues come in. When people are copying commercial objects, Barbie is patented, she's trademarked, she's got a string of attorneys up and down the West Coast. So I'm poking around on eBay, which is the best place to do copyright research. And I see these two things and I feel queasy. And I'm thinking, they forged Barbie's signature in the back. How can they get away with this? Is impossible. I think that, the photograph is just a beautifully done photograph, but how can they do this? So I dig around, go to the websites for the photographers. They'd gotten permission from Mattel. They knew they would be in trouble, so they got out of trouble. However, if you're doing Evil Skeleton Barbie 4, taking a Barbie and painting, fixing it up, this is fair use. I can look at this and feel inner peace because clearly we're not poking fun at society, we're poking fun at Barbie. We're saying this, we've seen 80 different kinds of idealized Barbies, but what about the rest of us? So this one, I don't have any problem with. Looks good. This one really makes my stomach churn. There's a reason I don't have the artist's name on there. I haven't found anything saying I got permission for it. The artist's website does say artwork is a great addition to any Barbie collection. There's Barbie's forged signature. I would know that neck anywhere. It's Barbie. So I can't stand it anymore. I've got to move it. Sometimes when you're dealing with trademarked objects, you think, okay, there are fixes. So these may look like Ford hubcaps. They are actually Boole hubcaps. Western Auto or their supplier thought, okay, we'll just avoid the trademark problem. Instead of writing Ford, we'll just write Boole and make it look a lot like Ford. the principle of trademark is to avoid confusion in the mind of the public. So if I were in to buy 1950s hubcaps and I didn't have my glasses on, I would be sure that Boole was actually Ford. I think the safer thing would be if it said Fool, and it was fairly clear that it said Fool, because then you could argue it was a spoof. It was poking fun at Ford, but Boole looks riskier. One last thing I'll mention with fair use. Often people will say, well, yeah, I copied it, but think of the free publicity they're getting. That's not a defense. It's like, yeah, it makes a lot of sense. It holds no weight in court. Maybe they didn't want your publicity. So just be advised, it's an argument that's often made. It doesn't work. It doesn't make it fair use. And closing in on the end here, what if my work portrays a celebrity? If I'm doing greeting cards, Christmas cards with John Dillinger on them. In Indiana has, I believe, the toughest rights of publicity laws in the US, and I don't know of a country that has tougher rights of publicity laws. Rights are covered for 100 years after the death of the celebrity. And the celebrity under the law is a person whose name, image, or signature have commercial value. So if somebody's going to buy that card, they're more likely to buy it because it's that person's name, that person's signature. It's under the rights of publicity. So, if you're doing, even if you're doing a card with a drawing of a statue of Hoagie Carmichael, if you're going to sell it, you need to clear the rights of publicity because it's his likeness. And just the last.
What if someone that hired you to do the likeness, saying review of that artist's work? Is there any implied permission that the artist or that the celebrity gives?
If it's not a commercial use, this applies for use in commerce. If it's, and I should add, if it's a single work of art that's not being reproduced, if you're doing a painting, a sculpture, a drawing, if you own any individual artwork, it's fine, it's not infringing. But if it's being used for commerce, for fundraising, then you'd want to look into it. The website for sort of the king of rights of publicity law firms is on the reference list. It's Roessler in Indianapolis, and I think they represent everybody from Dillinger to Malcolm X to Marilyn Monroe to James Dean and many others. So their website has a lot of detail. That'd be a first stop for some info. So just one parting thing, what about international law? With eBay, all these groovy things are crossing international borders a lot. So you can go on eBay and get an authorized reproduction of this Warhol print. And of course, the Maryland estate is involved. Now, there are, in the third world, if you read the New York Times, there are factories with painters with an original over here and the easel and oil paints reproducing great art. So you can get these reproductions. These are original oil paintings. And often in other countries, these may be perfectly legal. However, if they're being imported into the US, then US law applies. And even promoting them in the US can kick in criminal laws, and the US is actually extraditing people for infringing activities outside the US, mostly with the music and publishing industry. So, and I'll just say, often after a barrage of legality like this and illegality, people are thinking, you know, this is art. We don't want to get totally legalistic about all of this. That's right. It's like, this is one little slice of things. The best solution to problems is often to talk to people, think about their feelings, be respectful, ask permission, and it's a good way to stay out of trouble. So stay out of trouble. Thank you. Thank you. Yes. Oh, could you use the...
What about copying another image? I mean, there's two ways to do that, where you might do your version of a painting, you're doing a painting of a painting. I wanted to ask about that as opposed to, say, taking someone's print and putting it on your computer and doing all kinds of Photoshop things to it. So it's still that print, but you're mucking around with the colors or the wavy lines or what have you.
I don't think the technique of reproduction really makes a difference. So if you're doing, original copy or a digital copy, I think legally it's really the same. One thing people have tried to do to get around things is to scan in an artwork and go in and by hand just replace this set of pixels with another set of pixels. And it's just sweat of the brow labor. If you're ending up with pretty much the same image, if you do a perfect copy by hand, it's perfectly infringing if the original is under copyright and you don't have permission.
But I mean, for instance, in a class where we had a Chagall and everybody tried to paint it. And of course, none of them were exactly the same. But are you okay with that unless you sell it, then you'd be in trouble? Or,
Yeah,
you're putting your own name on it. You're not saying you're Chagall.
Yeah, so that's sort of the problem with the pastiche or what have you. Fair use does make allowances for educational uses.
Okay.
And certainly in the preparation of artists, that sounds like a circumstance where you'd have a very strong argument. So I avoid saying yes or no on things, but I think you could make a very strong argument to justify in that context. So it's. I don't know. It's better to say after Chagall than Chagall. I don't. It's a little bit. It would at least help you on a trademark suit against you, for example. I don't know that it'd get you out of the water, but if the original is yes, ma'am.
If you were an oil painter and you take your own digital photographs just down through the countryside, what are the consequences of that? I mean, are there any problems there or not? And the work you do is completely original, but you do big scene.
So it's a question of using whether it's okay to use somebody else's land or it's okay to use your own image.
Well, the picture I take,
Oh.
the hills and everything, it belongs to somebody.
Yeah.
For resale, you mean to sell the photograph afterwards?
Do a painting from it,
Oh, painting.
an original painting.
If the short answer is I'm wondering about it myself, I'm not aware of a problem unless you're using it in advertising or something like that.
It would be an original painting.
But if you're selling it's an original painting, I don't know of a problem.
Well, I mean, the Plein Air Society would go out all the time,
Yeah. I mean, there's such a
choose
tradition
places
of
to paint,
doing
so
it.
I wondered about that.
Yeah.
But a lot of times I take a digital photograph as a reference.
Yeah.
Where I'm at.
Yeah, the digital photo is not a problem as long as if you're photographing from space. Yeah, so that's so no, it's like it's not making me nervous, I'll put it that way. Yeah. Yeah, but I'd say, working from your photograph is no problem at all. That's your photograph, and you can do whatever you like with it. Someone else's photograph, then it's getting into reproduction rights, so that's a problem. Oh, I should.
You want to use the microphone, so if you want to pass it
Oh, so.
I have a question just on your last point. If you have a photograph of something that contains a trademarked item, and it's not an image of someone, but it is something like a box of SOS pads, how does the copyright law apply to that?
If there's some areas where it's a little dicey. If it's a picture of somebody in the kitchen and there's just a box there, sort of in its natural habitat,
It's incidental.
that's not so risky. If you're doing a portrait and most of the portrait is taken up with the Harley-Davidson image on the back of a jacket, that gets a little riskier. If the trademark is being used to attract the public to your commerce, and some of this is a stretch. I'm sort of extrapolating from some things outside art. It's also, trademark is an area I don't know as well as copyright, which is hard to know anyway. But sort of the prominence of the trademarked item makes a difference, and whether it seems to be naturally occurring in that environment, or whether it really looks as if you're using it to try to sell the artwork. So if there's a big Coke symbol, it's making me nervous. We follow the microphone.
Could you please elaborate a little bit more on the collage issue? Since collage is obviously by nature, in a way, a derivative work and uses typically, other people's either whole images or part images. For example, you mentioned that Rauschenberg was sued for using magazine images, but you also mentioned that if something is on a postcard, then that's not bad, so to speak. Are there any, because you may have many different images.
Yeah, I wish I had a better sense of where the lines are in this. It is safer to do the original collage because there, at least, there's an item that's been purchased, like a card, or the newspaper was purchased, the magazine was purchased, the source. So the collage itself, as opposed to a photograph or a print of the collage. So with Rauschenberg, a lot of the problems were coming up because he would prepare a collage and then do I guess he'd photograph it and then produce a silk screen from the photograph. So he was doing reproductions of collages.
So the collage itself is not a problem, but its reproduction is?
I've seen contradictory opinions on that.
So basically, we have no idea then.
It's. I have ideas, but I don't know. And there are areas of the law, for example, what constitutes publication of a statue. From before 78, the expert in American copyright law says, well, it's not really clear. So with some points, we don't really know until there's a lawsuit and the court clarifies it.
Because
so with
typically,
that, I really don't know.
Typically in collage, you put things, first of all, in a new context. So you modify it that way. And then also there are issues of combination. The combination itself modifies the...
Yeah, so
and then there are parts, how big the part can be. And that is used.
So it's a tricky area.
Just don't
There's an interesting website on collage. I did not put it on there because the person's Ernest is not an attorney, however, and not sure that it's reliable information. So I can point you to unreliable information.
So
but
we'll just have to wait until we will get sued.
there may be more things that I could turn up with research, but with what I know at this point, I really can't give a good answer. So, I'll follow your lead that way.
Could you just clarify again? I've been advised on my original works of art, it's not necessary to put the C in the circle and the
Correct.
date. Is that the signature creates the,
Neither one is necessary.
okay.
Neither one is necessary for copyright. When you've put the brush stroke on the canvas, you've done everything necessary to gain copyright. Yeah. An advantage to having, let's say, even a piece of paper on the back of it, or writing on the back of it, copyright 2005 in your name, it's consciousness raising. If the other person thinks, well, I bought this, so that means I can photograph it, display it, make cards and everything, at least it will help them stop and think, I own the object, but maybe I don't own the rights.
So that could be an attached tag to the object.
Just whatever will help get the message across. And you can always add a note saying, I, the artist, reserve all reproduction rights. The best way to get a hold of me is at this address or through this office. So yeah, the point there isn't so much a legal one as one of just giving people a reminder and access to you. The one sliver of a legal difference, if you do put a copyright notice on there, is the other people can't say that it was innocent infringement, that they just didn't know.
Going off of that one a little bit further, when I was in high school, I entered a contest that was, just a drawing contest, and I sent it in to the insurance company that was sponsoring it, and I don't know exactly what legal things were. I was only a student, I was just following my teacher's instructions, but the way I understood it was you send the picture to them and they never return it to you. They reserve the rights to copy it onto the calendar that it's published in and that kind of thing. And I was just wondering, do I have any rights to that as the artist, or do they take all of them?
You'd want to go back and, if somebody can track down the paperwork, or if you approach the insurance company saying, do you still have the paperwork on this? I want to know about the rights. As the creator of a work, you have the right to convey the rights to someone else, and that can be done through agreeing to something like that says, if you send this in, you agree to give us all rights to it. That's one possibility. Another thing that happens, you'll see a lot, is for magazines or things they'll say, all submissions become the property of the magazine, the newspaper, the journal. What that normally means is that physical copy becomes their possession, so they don't, so you can't sue them if they lose it or don't send it back. It does not mean, generally, unless they specify more, it doesn't mean that they hold all the reproduction rights and the copyrights. Where's the microphone? So.
You've made some references to the time span for the copyrights, but I'm not clear on it, and I'm curious for us now, either registered or not, and also what about a postcard from the 30s?
Okay. So if you create something today, it will be under copyright until, exceptions, but, vanilla case, it will be protected until 70 years after you leave this earth or go back to this earth. The exceptions would be if it's an anonymous work, if you do it under a pseudonym, if you do it as a work made for hire, but those are things, but just your basic thing, registered or not, 70 years from your time of death. A postcard in the 30s, if it was published without a copyright notice on it, it went into the public domain immediately. If it did have a copyright notice and it was published in 30 and the image hadn't been registered or copyrighted before, it came up for renewal in 1958. If they failed to renew the copyright in 58, it went into the public domain. If they did renew the copyright, then it depends on whether it's anonymous or pseudonymous, or if the artist is known or the artist becomes known. If the artist becomes known, then it's 95 years. So it'd be 2025. And if it's anonymous or pseudonymous, it would be 120 years from creation or 95 years, it's 95 years from publication. And that's one of the easier cases. This is...
For those of us who are textile people, and we buy a lot of fabric in fabric stores, and it'll say copyright. Sometimes they're famous textile designers who have a series of fabrics, and it'll have a C on the edge of the fabric. Does that mean we can't use it to sell, make a product to sell? I was assuming when you said that it's copyrighted, that artists received their money through the textile company for their design. It was put out in the market to sell, that we could use the items that are being sold.
I've never thought about it. And it's a sort of question I really, really like.
Well, it would seem to me that they're putting it out there, selling yardages and hundreds of yards of this stuff all over. Like, no chair.
Just keep it.
Yeah.
Okay. I think we all have relatives who do just that. They have the attic full of fabric. I think the first legal argument that comes to mind is, what do you think people are going to do with it anyway? Of course they're going to create objects out of it. Right. On the copyright side of things, I don't think you're really making a derivative work if you make clothing out of the cloth, unless you start altering the pattern. If you're painting on the design.
No, the question is whether we can sell it using that material that's copyrighted.
I don't see why not. Partly on the argument that they know that it's a foreseeable use.
And the artist has already received money for the design, and probably has a licensed agreement with the fabric producer, with the textile company.
Yeah, I don't want to say never, but I find it hard to imagine an infringement suit unless, let's say, you took a panel of it, framed it, and then
put your own
name. Put your own name on it, or you started altering it, which is sort of a far out case. But I think if you're producing something with a fabric and selling the object.
Similar to the note card.
I'm thinking it doesn't sound like a derivative work to me, but that is not legal advice. That's just me pulling something out of my right ear.
Okay. And I have seen material that said may not be used to resell. But most material does not say that, so I don't know.
So I'll have to get off eBay, go down to Joann's with a notepad and see if there's a phone number or a website where I'd love to just ask them what their sense is.
Yes, we can give you some names to call.
Please do.
I want to thank you very much,
So-
Jeff, for being here today. This is obviously a very deep and difficult topic. Who knew? Let me just remind you that in October, on the 25th, we'll be having another very chewy topic, art and the IRS. So we look forward to seeing you then. And if you have more questions, I'm sure Jeff
Sure.
will be willing to answer them. Please turn in your evaluations, send in your membership,
Hi.
Hi.
and thank you for coming.
My question has to do with, like, what about the context of journalism?